Yeah.
All right. Okay. All right. Well, thank you very much, everyone, for joining us. Thank you to our speakers, especially, and to the Resolve Academy, Melina and Tatovic, for organizing this. So this is a series of webinars that are put on with the Resolve Academy and Mediation Chambers. The idea is to be promoting mediation, to be talking about mediation, to do everything mediation related. So we are putting on this series to bring out other topics and to have a general discussion. So we're going to be, I will be moderating in this, and we've got our fantastic speakers. So we've got Surinder Kalra, who is, so he is actually a member of Mediation Chambers, but he has a lot of experience actually in, sorry, give me one sec. Let's pull up your experience here. So he has a lot of experience in finance. He's a chartered accountant, and he's got 43 years of practice in the field, actually, and for mediation. He successfully conducted more than 2,000 mediations. His expertise is recognized through his accreditations. He's accredited with the Institute of Chartered Accountants in India and the Delhi Dispute Resolution Society. He's affiliated with several prestigious organizations, including the Indian Council of Arbitration, the National Consumer Dispute Redressal Commission, and the PhD Chamber of Commerce and Industry. He's got a lot of experience in construction mediations as well. He's mediated in a number of different jurisdictions. His international connections taken from Mauritius to Mongolia and Bangladesh, as well as India and beyond, I believe. His expertise also spans a very diverse range of sectors. So he specializes in environment, social and governance, ESG issues, Sharia financing, aviation, banking, construction, corporate matters, and employment disputes. And his list of credentials go on much further than that, but I think I might stop there.
Yeah.
That's thank you very much, Surinder. It's great to have you with us. So our next mediator that I'd like to, or speaker, sorry, that I would like to introduce is Kamala Naganand, and I hope that I have said your name right. I'm sorry that I tend to butcher everyone's names, so many apologize to everyone. So Kamala studied law at the University of Law College, Bangalore, and she completed her master's in intellectual property law at the George Washington University Law School in DC. Her principal areas of practice are corporate advisory, data privacy, intellectual property, and private client practice. She started her career at a family-run law firm in India, and then she co-founded Just Law. And then she went on to set up Anna Law with her partner, who was also a mediator. So she has started various initiatives to bring more women back into the workforce. And so by doing that, she offers flexible hours, integration of technology into the practice of law. She really likes to promote women in law, which is fantastic. Of course, close to my heart. So, and in the wake of the COVID pandemic, the technologies that she introduced into their practice allowed for a seamless transition to work from home. So this helped actually people in Anna Law and presumably your clients as well, an awful lot. So she heads the intellectual property, media technology and data practice at her firm. She's worked in the management of intellectual property, licensing, and branding exercises for both startups and large companies. And her passion for art has driven her to be active in the art law space and built Anna Law's practice in the field. And you should have a conversation, by the way, with Camilla about art law. It is fascinating. It's something that I really want to dive more into and learn more from her about. So Camilla's list also goes on very far. So I will stop there. She's a really fantastic person to have on our panel today. So thank you very much for joining us. And Narek is Narek. I want to say your last name, but I know I'm going to get it horribly wrong. So I'd like for you to say it for me.
It's all right. It's Narek Sahakyan.
Sahakyan. Okay, thank you very much. Okay. So Narek is a practicing lawyer and a mediator. He has over 5 years of experience in dispute resolution. He is the co-founder and managing partner of Locus Legal Consulting. It's a Yerevan-based law office and a permanent mediation center. And he leads both the legal and the mediation practices. And he focuses on traditional as well as alternative dispute resolution mechanisms. Alongside his role as the head of the mediation center, Narek also actively mediates a wide range of disputes himself. He is passionate about promoting mediation as an effective tool for conflict resolution, and he regularly works with both individuals and organizations to foster constructive dialogue. From his practice, Narek is dedicated to raising awareness about alternative dispute resolution in Armenia and sharing practical insights with the legal and business communities. So also someone very much after my heart, after my own heart. I'm also very, very passionate about alternative, any kind of ADR mechanism, mediation being my absolute passion. So I'll do a very brief introduction of myself. I'm Alex Povey. I am the director of Mediation Chambers, which, as I said earlier, is one of the 2 organizations who's putting on these webinars. So, and I'm a practicing mediator, as well as doing a number of other things as well, working in ADR. But mediation really is my passion. So let's get on to our conversation now. And I'd like for the audience members, by the way, if you have questions, please do ask them. Put them into the chat. And if it's appropriate at the time, I'll ask them. Otherwise, I'll bring them up at the end to ask. But we do want this to be interactive, so we want to hear from you as well. We want to hear your questions. And we'll be very, very happy to answer them. So this webinar is talking about sector-specific mediation. Now, a lot of people think that a mediator can mediate any dispute. And in theory, this is true. But there are some challenges, and different people have different views on this topic as well. So if you're mediating a specific dispute in a certain industry, you might think, would you take on a mediation in an industry that is not your specialty? Some people say yes, some people say no. So if you do say yes, if you think, yes, I can take on any mediation, how do you approach disputes in areas where you may not have that technical or subject matter expertise, such as real estate or technology? So that's really a question that I'm putting out to everyone. So I will start going around. I have you on my screen, so I go around in a circle. So let me ask Surinder this first. So if you're mediating a dispute not in your specialty, what would you do? How would you approach it first?
In fact, thank you very much and welcome everybody here. Thanks for your nice introduction. In fact, for this mediation part of it, I've been doing it now for the past 40, 45 years. In India, as well as in other countries. In India, for arbitrator, there used to be certain qualifications that minimum 10 years experience was required. But for mediation, we have had the law only from 2023. Otherwise, it was all free. And to be very frank with you, I have been more, even though I am a chartered accountant and finance has been with my 40, I had been more successful in matrimonial mediations and family dispute mediations, even though I have my expertise in IT, blockchain, IoT, artificial intelligence, but still, there we didn't get much of the disputes. Only very recently, India has come out with a Data Protection Act and laws. So disputes have yet to arise in that area. Particularly, even though in India we have 3, 4 major religions, religion is Hindu, then Muslim, Christian, then others. Even though I have been born in a Hindu family, but I have been more successful in Muslim or Islamic matrimonial cases, in the sense that there were. I'll give you a very classical example. India is a vast country as compared to, but maybe Canada geographically is much bigger than India. In the south part of India, almost every family has got 1 or 2 members who are settled either in the Gulf countries, UK, USA, like that. And most of them have gone to the Gulf countries. And there, what they do is, I am just giving a live example which I have undergone, is that the gentleman goes there, goes for a job, finds a mate. She is from Indonesia, get thicker and thicker. And one day he sends a WhatsApp message, talak, talak, talak. In Muslim law, if you send these words 3 times, so you're gone. And thereafter, he will block that lady also. So how to settle such cases? They have been classical cases. I have met other cases also where they were both sitting in front of me and they started fighting. They were at fits and they started slapping and boxing each other. And then thereafter, they went cool. So all those cases we have had, even though I never learned these laws, but still, I have had good success in this. It is not that. Only thing is, it is more of an art than the law actually doesn't come much into the play. Law comes into the play when you have to threaten them or some alimony or there's a divorce case. But if there is a success in that case, then I don't think the law would be required.
Okay. Interesting. So you feel that the process of mediation actually can be used to find a solution as opposed to actually going to the law, going to anything. Interesting. Thank you. Okay. And Narek, actually, sorry, you're now next on my list. So please, do you have anything that you'd like to add to that?
Thank you very much, Alex, for moderating this webinar, and of course to Resolve Academy for organizing this event, for giving us this opportunity to talk about mediation, about one of my patients. So regarding the question, my short answer would be yes. My short answer would be a positive answer. And my longer answer would be the reason why I say yes is that because I believe that as a mediators, we are not judges. We do not have to be an expert in the field. That's just not about mediation. Mediation is about bringing parties together, guiding them through the whole process, bringing up their real needs, and thus getting them closer to a mutually acceptable solution. And throughout that process, of course, we need to have enough knowledge, enough skills in the field as well, because if somebody comes up to me and says, we want to appoint you as a mediator for in an industry that I have no any idea, if I accept, if I agree to take upon the case, I should do my homework very quickly. I should learn about the specific industry, about the tendencies in that field, in order to be able to be competent enough to mediate that case. Why? Because in mediation, parties ask a lot of questions to the mediator. When we hold separate meetings, especially during those separate meetings, the parties ask too many questions, and sometimes if you do not have enough knowledge in that field, it will be really hard to put yourself as a competent mediator. Therefore, I believe that yes, it is possible to take a case in a completely new industry, but if you do so, just make sure you do your homework and you put yourself as a competent mediator, because that's how we gain the trust of the parties. If they do not trust us, the mediation cannot be successful.
Yeah, absolutely correct. Very interesting. So yeah, so a little bit of preparation at the least within that industry. But you believe also then the process is something that really helps to guide the mediation to get to a resolution. Is that correct? Okay.
Yes, absolutely, because that is essential. Without it, I cannot imagine myself mediating that case.
Okay, thank you. All right, Kamala, how about you? Because obviously you did some very specific mediations, I believe. So how do you feel about it?
Good evening. Thank you, Alex, for the question. I think it's a very good point to start, because as mediators, I think preparation is the key. So whenever I'm looking at a mediation, regardless of what industry it is, I first do a little bit homework on the parties themselves to understand what is the kind of mindset they have. Are they people who are able to, resolve conflict, or are they people who believe that if they were to come to the negotiating table, they lose face? So I think understanding the mindset of the parties is extremely important, because that's the role we play, right? Navigating through the complex issues and the emotions. I think the second important part that I look at is understanding the industry, as Narek said, right? We've got to do our homework to understand what kind of an industry it is. What are the gold standards there? How many settlements do take place? And if they do take place, what is the role of each party in that settlement? Because I think, again, this is a very cultural issue. There are some countries who take offense if they were to come to a mediation, because it's just not part of their cultural nuance. Whereas some parties are very open to it because they just want to get on with the work. For example, in a tech dispute, they cannot go to court and, negotiate or even argue the matter for 20 years, because most court systems today are extremely bogged down and they don't have enough judges who understand the technology. Therefore, in such cases, it's very, very pertinent to either go to arbitration or mediation, because one, you can bring in technical experts. Two, the time value of money for these technologies are extremely important. So if they, are able to resolve the issue in, say, 3 months as compared to 10 years, of course, they're going to take the 3-month route, because in 10 years, that technology might completely be obsolete. So I think doing my homework to understand what the nuances in that particular technology are extremely important. One of the examples I can also give you is AI. The role of AI is changing so dramatically. What is today AI is changing. So recently I've been negotiating with an employer, or rather a startup founder and his CTO, Chief Technology Officer, because they developed a product, but he was not able to put in the AI functionality. And so there was a dispute between the co-founders themselves to say, how do you resolve this dispute? Because the CTO was not doing his job. In such a case, understanding AI, understanding what were the AI functionalities and features that they wanted to put in, and why the product failed was extremely critical. And so I'm very happy to say we were able to, come out with a solution that was a win-win for all and wind up the company and, move on, such that they were able to then use the money that they had brought in from various co-founders, from various investors into another project, bringing in another, technology lead. So I think understanding the industry is extremely, extremely important when you're beginning the process of mediation.
Very interesting. Very interesting. Thank you. Yes. So it sounds like that you also then agree that it's the process is important, but actually understanding the industry, so doing that research is kind of the vital part, it sounds like to me.
Absolutely, because we are the fulcrum on the basis of which the whole dispute is going to be resolved. So, understanding all parties, understanding the nature of the dispute, understanding the industry, and being that malleable process driver, so to speak, is our role as mediators.
Yeah, absolutely. And yeah, I think that with technology changing so rapidly, I can see that this is a very important area for mediation, especially because you're right, people can't sit around and wait, can they?
Absolutely. And what's interesting about the technology space right now is that no country really has definitive laws and regulations around it, right? So it's really like everybody is in no man's land. And so we've got to kind of use, our law of torts, law of contracts, the various laws available, which are already, in place to kind of navigate these sensitive issues and create boundaries. So really, technology has gone 10 steps ahead of the law. And so what we're really having to do is kind of catch up with the law, but the law is not able to catch up because technology is moving at such a fast pace.
Very interesting. Surinder, you have something to say about this, please.
Yeah, in fact, I agree with both the gentle speakers in the sense that one has to do some homework as far as the case is concerned. But as far as the deep understanding of that technology and other things is not that necessary, because we are trying to mix what an arbitrator, the difference between an arbitrator and a mediator. Mediator is a person who has to reconcile the mindset of the other, with both the parties who are not particularly in the realm of, maybe to the extreme, they are not even in talking terms. So we have to meet them at a place. And for that, I don't think I would need the knowledge of artificial intelligence or anything from airlines industry or anything of that sort. No. And suppose there is a workplace mediation going on. Best I can try to understand is that what are the bylaws of that company and what does it say about, say, sexual harassment or timings or overtime payments, like that. That's all. I need not go into the labor laws and all those things. That is the realm or the duty of the arbitrator to understand. Only thing is that the solution has to come from the disputing parties themselves. As a mediator, I have not to give the solution from the law or the technicalities of those things. No, it is they better understand everything about their workplace, their technology is better than me. So as a mediator, I have to only bring them to a common table. That's all. And the only thing is that I can help them in drafting the mediation agreement, whatever they have done. That's all.
Right.
It is not that I have to give any input into it. I can check the grammar, I can check the spelling, I can check the full stop, comma, all those things. As a mediator, it is not my duty to give any technicalities or any suggestions to them. Otherwise, I'll be going into the duty of an arbitrator. You see, I was in Canada, I studied their law. There are certain institutions there, they have rules called, where there is a paragraph in the rules called MEDAB rules. And the same person who is a mediator can also be an arbitrator. Wherein most of the other countries, UK, India, Dubai, or even probably Singapore has MEDAB rules. But only thing is that a mediator in India is not permitted to do the same case as an arbitrator. He can be an arbitrator in some other case.
Yeah.
So we should not try to mix those things.
It's true. Sorry, carry on.
Yeah, please carry on.
I was saying it's absolutely true. I mean, I think sometimes there's different models of mediation. And so I suspect that if you're doing a facilitative mediation, then yes, you're following the process, and the way you're explaining it, it's correct that yes, you don't need to be an expert. If you're doing evaluative mediation, then I would imagine that you would need to be an expert, though. So I think possibly it depends on which type of mediation you're, and I'm just speaking here. But that would be my take on this. It's possibly the way the mediation is being conducted as to how it is resolved, and as to how if you need to be sector specific. But I know that everyone does have very different views on this, and it can be quite divisive as well, this topic. I know I've had some quite passionate conversations with people about it. So anyway, I think I will move on to the next question though.
Okay.
Unless if you want to put in, if anyone wants to add any more, I'm very happy for you to. No? Okay. All right. So the our next question is really looking at industry specific dynamics. So, you know, we've heard already that that some people do feel that you need to really be very specific in your industry, but different industries have got different conflict drivers and different time and cost pressures. And so one of those, so Surinder, you work in construction, or you do mediation in construction, I believe. What are the main conflicts that you find in construction disputes or in finance disputes or the other types of disputes that you're looking at? What are the main drivers?
I go one by one. Finance has been from the day one when I completed my chartered accountancy. And in financial matters, normally, say we start with a small bank has given a small loan to somebody, some housing loan or a consumer finance loan. Only thing is that the dispute may arise as far as the repayment of the EMI is concerned. He may ask for certain concessions because he lost his job and he could not pay it. Similar situation could be there with an industry where the profits have gone down and they're not able to repay the loan in time. And there could be a situation, then a bigger scenario would be that there is a private equity fund that they have invested it in some company and there is a investment agreement also. It could be a FDI agreement, it could be a BIT agreement, and those things. India is not a part of the World Bank arbitration process, but BIT for arbitration and mediations is there. In the sense that recently India has entered into a BIT with UAE and UK also, wherein there is a dispute resolution clause and they start with mediation only. And thereafter they have a process of arbitration. The procedure has been set up in both the BITs. As far as construction is concerned, construction is beset with a lot of disputes. Everywhere you take one step and resolve that dispute, another step, another dispute. Sometimes there will be quality dispute, sometimes there would be time extension, sometimes there will be force majeure. So many things are there in construction as far as infrastructure, roads, and other projects are concerned. And in that case, what has happened is there are certain models which, in fact, the infrastructure projects are very costly. And World Bank had come out, say, around 25, 30 years ago with a model concession agreement under the PPP model. It is a PPP, public-private partnership model. And it started with BOOT, build, own, transfer then. And then it had little modifications in EPC contracts, item rate contracts. And then there is the latest one is HAM and DBFOT, where the contractor himself designs and he does it. And after the construction period is over, there is a maintenance period in which he gets the toll or revenue out of it. And there could be a negative tolling also. And he has to share a portion of the toll or revenue which he gets from that infrastructure project with the government. Because government has given him the land. So in such cases, there also they have an internal dispute resolution board, which is virtually like there is no third party as a mediator, but there is only two parties are sitting there. And thereafter, if the dispute is, suppose they have 10 disputes and 6 are settled, then the 4 balance they can go for arbitration. And in arbitration also, it could be ad hoc, it could be an institutional, both. Then there also, whatever the award is given, suppose it is given against the government has to deposit 50% of that money which is awarded in favor of the contractor into an escrow account, which is not to be withdrawn by anybody. Only after the court intervention that will be given to the contractor, and then if it is 100%, then 100% goes to the contractor. So this is a multi-layer and multi-tier agreement which is there. Similarly, there is a standard format given by FIDIC. FIDIC is a construction consultancy organization which has got headquarters in Geneva. And there's a red book, yellow book, green book, and golden book for each type of construction contract. Whether it is a turnkey project, whether it is a EPC project, whether it is a consultancy project, all those types are there. And even for small projects, there's a green book in which the standard formats are referred. Even UNDP has also come up with certain guidelines, and they have given certain templates. Because what happens is that whenever there is a tender for any infrastructure project, the government will ask for a bid bond guarantee or a performance guarantee also. UN has given the formats of those bank guarantees and performance guarantees also. Or they have to be formatted. There's a template.
I see.
If somebody wants, I can share those templates also.
Thank you. Thank you. Wow. So construction mediations, construction disputes actually are very specific. It sounds like you have sort of very formulaic as well. And they seem to sort of hit on similar areas, let's say. So you can, I would imagine that a construction dispute would be the time, pressure, and costs also would be very, very important, right?
Yes.
All right.
Timelines are very important. Otherwise, you see what happens is that unless and until the timelines are met, there is an escalation in the project cost. Everything will go out.
Yeah.
Steel prices, cement prices, they are going up every day.
Yeah, so people do really want to resolve them as quick as possible.
Yeah.
Yeah, very interesting. So it's very relevant for construction disputes. Thank you. And Narek, so your areas that you work in, I believe that it's finance related. Is that correct?
Yes.
That is
Oh, sorry.
correct. That includes finance as well.
Okay. So for you, do you what are the conflict drivers and time and cost pressures that you find within the area for that sector specific area? And give me others as well.
Yes, thank you very much. This will not be very surprising to hear that in this sector, the most conflict drivers are usually loan defaults, repayment issues, sometimes even regarding the treatment, the communication, misunderstanding between the bank and the client. Sometimes it could also be regarding the bank and the regulatory authority, but unfortunately in Armenia we cannot mediate such cases between the banks and the authority and the regulatory bodies. For example, in Armenia, that would be the Central Bank of Armenia, who is the regulatory body in the financial industry. And the Armenian law says that we can mediate only civil disputes of civil nature, and that nature and that conflict between the regulatory body and the bank is of an administrative nature. Therefore, sadly, we cannot mediate such cases. So coming back to the disputes between the banks and the clients, as I said, they are usually about just repayment issues, but sometimes they can also arise from the mistreatment of the client, as the client usually come to us and say during the mediation processes. in that regard, as I said, I have over 5 years of experience in the banking sector, and while I was in that industry, I have been involved in the several mediation cases, acting on behalf of the bank. So now, being a mediator, I understand well what are the needs of the banks. That because sometimes, the parties, the sides come here and they say, I want this. The other party says, no, I want this. I want X. I want Y. But in reality, their needs can be much different because their needs are buried in a deeper layers. It can be just as simple as respect, mutual respect. I don't know, the being felt secure, the security, and such emotions can be more important for the parties sometimes than what they come up to see in it, come up and say initially. Of course, we have some challenges as well in the financial industry. For example, if the parties do not settle, we have an issue regarding the money that is due. For example, the interest rates, the penalty rates, they add up every day. So every day we do not reach an agreement, we kind of damage the client because the client is getting more, the obligation of the monetary obligation of the client raises. But on the other hand, we cannot hurry up just to avoid that, because in mediation sometimes we have to slow down. So hurrying up can also damage the whole mediation process, can tank the whole process. So we have to kind of find the right balance between that, to not damage the client, but also not to tank the whole mediation. It can be pretty challenging, but it requires enough skills to create that safe environment in the mediation room so that the both parties will slowly come closer to that zone where their needs and where their needs collide. So, yeah.
Very interesting. Wow, there's an awful lot to unpack out of what you've just said there. Thank you. Very, very interesting though. Okay, I feel like that's a whole other conversation actually.
Yes.
Some of that.
Yeah.
Wow. Okay, thank you. All right.
I'm sorry, Alex, one point I missed, what Narek has just said. In India also, we have lot of mediation for the credit card repayments. And lot people may forego certain things, and they have spent more than their salary or anything of that sort, and they're not able to repay the where they have used the credit card. And then mediation comes into picture there also.
Interesting. Okay.
And in India, there is a very big problem here is that if the borrower or any credit card holder asks for certain concessions, then his rating goes down. There's a rating institution called CIBIL, which is under the Central Bank of India. It's a private company. But then the rating of that person will go down, and it takes almost a cooling period of 5 years to recoup his rating. During the hot period, he cannot get any loan from the bank again.
Interesting. Okay. Yeah, I think those ratings, I think we have them in different countries, in other countries as well, I believe. But yeah, very, very interesting. I think that within banks and regulatory bodies, mediations can be useful. But yes, challenging, very challenging. Thank you. So Kamala, for you, perhaps you could give us some input in whichever particular sector you want to talk about, if it's family law or art law as well is also okay. If you could give us some information on that.
Sure. So I'll first talk about commercial which are, family businesses. In India, we have a peculiar situation where a lot of our businesses are family run. And so in such situations, what ends up happening is that there are two dynamics. One is the business and the issue itself. And the second is the dynamics between members of the family. And so what we see is very often, it's really not a business dispute, it's a family dispute. but the business gets involved in it and the business kind of gets stuck in it. And so what ends up happening is there's a denuding of value for the promoters, for the shareholders, for the employees. And so I think what the dynamic there is of kind of trying to figure out who the figurehead is in the family, who's then going to be able to be the voice of reason to resolve the dispute. And sometimes, when large business families are there, they're used to a patriarch calling the shots. And so when that patriarch is no longer there, it really, really disintegrates the value system, because it's only now in the last 3-4 years that these families have put together things like family constitutions. So while it's very, very popular and something that's, happened for over 30 generations in Europe, this is something new in India. And that's really the key to kind of helping put in dispute resolution mechanisms in these family holding structures. The second important thing that I see is that as these family dynamic changes, business succession, I think, is now becoming more and more important. I think the earlier generations were very, very happy to go out and build the businesses. Now they're 3-4 generations in, and the 3-generation rule, right? So everyone is now trying to avoid that 3-generation curse of disintegration of the family business by putting in regular structures in their family constitutions. And I think that's where we've been playing a very crucial role, is to understand the family dynamic, understand the cultural nuances of each family. Because see, India is like Europe. The north of India is very different from south. The north of India is extremely contentious. They do not like to settle, whereas the south of India is really the brains of the country, where they're the, tech-enabled entrepreneurs. And really, the economy is running on 5 states of the south of India, who are bringing in the maximum revenue for the country, right? And so what happens is that because of multiple layers of education, the south of India is educated for over 5-6 generations, whereas the north of India, I'm not saying all families as a general, but they're now beginning to be educated. So they'll be a 1st or 2nd generation education. And so the empowerment of women is becoming a big concern, because in the south of India, like my grandmother had a double degree, right? And that was normal, and it was okay for me to go out and work. Whereas in the north of India, that's still not okay. Women cannot sit on the boards. Women cannot succeed in the businesses. There is recently a very, very big South Indian family who had a big dispute. The chairman passed away, and in his will, he put down his only daughter to succeed him. But the whole family stood up and said, no, she's a woman and she's not allowed to be a part of the business, and therefore she should get out. And this is a lady who has a PhD in aviation and aeronautical engineering, right? She's on top of her game. And so she took it all the way to the Supreme Court. Finally, she got her rights, and then she settled with all her cousins. But at the end of it, she had to move out of the business. Right? So what I'm trying to say is that women empowerment is a big role. And what we are now going to see over the next 5 to 10 years is that women who are educated and who have the ability to take on the business roles and business mantles within family businesses are not going to be doormats and say, listen, we are going to keep quiet and we're going to let the men handle the business. And we're only going to be silent shareholders. There are certain families who have family constitutions that very clearly say women are not part of it. They will be given shareholding, but they will not be allowed to sit on the board and active management. There are other families who say they will not be given shareholding also. They will only be given a large lump sum settlement at the time of their marriage. And so they have to exit any rights they have. So I think, the dynamic is changing of how to kind of bring about settlements when technology is changing rapidly, family structures are changing rapidly, financial empowerment is happening of women, and the role of women is changing in the society. And I think that's what India is going to see over the next 10 years. Because if you're sending your child, boy or girl to Harvard or, any other, marquee institution, is she going to come back and sit at home and do nothing? So I think this patriarchy, especially in the North, right, is going to be slammed very hard. And they are going to have to change the mentality of men to be able to ensure that women are given rights at the table. And I think that's really going to be the key. And I think mediation plays a fantastic role in this, because I'm seeing that it doesn't destroy families. It keeps the family together, and it also keeps the business going.
Yes.
If this were to be a dispute, the business suffers, the family suffers. So I think mediation will play a fabulous and really, really marquee role in these family settlements to be able to ensure that the rights of women are protected, the business continues to function, and they're able to scale and grow.
Wow, also really, really interesting. I'm saying the different sectors, you're, three of you are
Very good
quite
analysis.
fascinating. And it does show actually how powerful mediation can be in these different sectors, doesn't it?
Absolutely.
Isn't it? Really is.
Absolutely. In this family dispute that I spoke about, Alex, it is one of the largest South Indian families in and with a huge shareholding.
Okay.
You know, all of them are men.
Wow.
And imagine having to, you know, destroy that large family business, which is providing employment to so many people, and which is also adding to the net worth of the country, because they are really bringing in a lot of revenue into the country. Right. So for such a family to be destroyed because they couldn't change their mindset to present social norms and conditions is really sad. So I think, you know, mediation was the only approach here, because otherwise it was just destruction of business.
Yes.
Right.
Yeah.
And another fascinating thing is that a lot of these family businesses have cross holdings. Right. So it's not easy to kind of break it up and say, okay, fine, you take this part of the business. It is very difficult to do that.
Yeah. Right.
Because of the cross-holding structure, everybody owns everything. That's the way we think, right? As families, that was the safety blanket. And so one of the interesting concepts is called a Hindu undivided family, which is again our Hindu personal laws, where it allowed families to hold wealth together.
Okay.
Right. And it allowed you to hold financial assets as well as land, as well as business shareholding. And so the role of that was to ensure that every member of the family is protected. Right. And so when everybody holds assets, then if there is somebody who's not doing as well, he has the safety blanket that the others are also working, and so he'll get compensated. But he plays a different role in keeping the family together. Right. So the Hindu undivided family role is also going to rapidly change, because this government presently is thinking of something called Uniform Civil Code, which is ensuring that all our personal laws are eliminated. Right now in India, like Mr. Kalra said, each of the religions have their own personal law. So we have Hindu personal law, we have Muslim personal law, we have Christian personal law. Now with this the new law coming in, we will all have to follow the same regulations. And so, you know, laws which were made for over 300 years are now going to be eliminated. With that, there is going to be a huge change, because, you know, our succession, our birth, death, divorce, all, and holding of family property, all that is under all the personal laws. So there's going to be a radical change in India that people are not able to understand, right? And it's really going to impact how we're able to think and how we are able to protect various members of the family. Because even till today, 90% of Indian businesses are family run. It is a very, very high number.
Interesting. Wow. I had no idea it was that number. Goodness.
Yes. So there is going to be a huge, you know, change in this, if this new Uniform Civil Code is going to come in.
And with the backlog in your systems, mediation is then going to be even more important.
Absolutely.
Yeah, in fact, what Kamala was telling, the Hindu undivided family structure, that is among us the Hindus, there is a term called co-partners in that law. Co-partners mean co-partners. And a female cannot be a co-partner, only male are supposed to be the partners in the property.
Okay.
No, but that regulation has changed after the
That has changed recently
2005
only.
Supreme Court order, where women can also be co-partners now, and women are also have an equal right to share in property of the
That
ancestral
is an
property.
interpretation of the Supreme Court, but the jurisprudence, as far as the act was concerned, it was the co-partners who were the male members only.
Okay.
But our Constitution is a very interesting constitution because it is also allowed to make laws. So under that, it changed the regulation and made it after 2005, women are also allowed to be equal co-partners in their ancestral property. But again, it depends on the interpretation and how each family wants to interpret it.
Wow. Okay, so it does sound like then definitely mediation is becoming more and more relevant by the day.
One more thing in the construction contracts, I forgot to tell, the government Ministry of Finance in India has come out with it is not a regulation, but it's a recommendatory circular, which it has come from the Ministry of Finance because of the ill effects of ad hoc arbitration, wherein most of the retired judges were appointed as sole arbitrators, and they used to prolong the things, and the awards were also so flimsy that they were disputed, and they used to go to the court, and then again the litigation used to start, and the cost benefit analysis was totally lost as far as arbitration was concerned. So they have come out with a circular that any amount dispute which has an amount of 100 million rupees, they will not be arbitrated. They will be first mediation will go on. And almost 5 or 6 provincial governments and PSUs have adapted that circular, and they are doing away with arbitration and they're going only for mediation. Whereas you see, it has been a big blow to the arbitration sector in the sense that government is one of the biggest litigants in India. Almost 70% of the litigation, the government only is involved. And if the government comes out of the arbitration process, there's going to be lot of revenue loss. But only thing is that it is the retired judges who have spoiled the entire show.
Okay, interesting.
Retired judges have not proved to be a good mediator or even good arbitrators, I have seen. They have their own tendency of yelling, giving them dates, and after that nothing happens, prolonging the things.
Interesting. Wow. Okay.
If I may come in, Alex, I think another important change in our, systems are going to be our land regulations. So like Mr. Kalra said, if the government is the largest litigant today in our courts, whether it's the Supreme Court or the High Court, and a large part of these matters are matters with regard to land laws. But as we speak, the government has put in a new policy where they're going to ensure they use blockchain and actually make sure that all our land records go digital. And so what then happens is that 90% of disputes with regard to real estate, or at least land holdings, will stop, because now nobody can either forge papers or identify a property as theirs when it's not actually theirs. And so this kind of technological change and empowerment, right, is going to completely transform the way India is going to be. Because imagine out of the 90% of the disputes which are by government, 50% are with regard to land, either land being squatted on or land being taken over. So our courts are suddenly going to be, unburdened by ensuring we bring in technology and ensure that all our land records are digitized and transform this. And it's already happening in Karnataka, where as we speak, they have digitized nearly 95%. And so this was a pilot project in Karnataka, which was then going to be taken all over India. And so now that they've put this system and process in, they're going to slowly move it to every other state. And so it's really, really going to transform the way we're going to be able to see disputes. And the disputes now that are going to come to court are going to be very, very nuanced and very, very specific. Because if there is no issue with regard to real estate holdings, the courts are then going to have other important issues that they'll need to learn. I think the second important issue is for the judges themselves and what he said, right? A lot of our judges will need to be trained or retrained in a lot of these technology-based questions that are going to come up. And so right from basic land laws, they're going to have to move to answering more complex questions. And so again, I feel like what you're talking about, right, ensuring that mediators come in with sectoral specific domain will really, really play a key role, just like how it happened in arbitration, where there are certain arbitrators who are very well known in construction arbitration or very well known, in family settlements, well
Yeah.
known in specific commercial mandates. So I think retraining will be the name of the game over the next 5 years.
I'll give you my experience in this blockchain in the land records. What I found is that it is not only the state of Karnataka, almost all the states, provinces in South India, they have started implementing or they have completed the entire records. More than 80% of the land records have been put into blockchain. I took up this matter with my state in North India, a couple of states called Haryana, New Delhi, or even Uttar Pradesh. The revenue minister or the land record minister or their secretaries who are civil servants, they don't know even what is blockchain. They've never heard of it even. That is the level of literacy they have in IT in North India. I really agree with Kamla that the literacy rates and even the sex ratio is favoring the female in South India. There are certain states called Kerala where the female ratio is more than 100%. And in my state where I stay in Haryana, it is almost 80%. So a lot of girls from Kerala, they come and marry in Haryana, in North India. Because there are scarcity of boys there in South India. They come and marry with the North Indian boys.
Okay. Oh, interesting. So it does sound like there's a lot of changes going on in India, a lot of interesting
Yeah,
things.
in fact, India is a very vast country. It is like European Union, I would say. The European Union has got 28 countries. We have got 28 provinces. And each province has got its own language also. But currency is the same.
Okay. Interesting. Thank you. Wow. Okay. Gosh. So I think I'd really love to hear actually, Narek, from your side of obviously having heard all of this now from Kamal and Surinder about India, their experiences, all of this. And I'm sorry, I'm going a little bit off piste here. But I'd be really interested to know how mediation, I suppose, is evolving over there. And are there particular things that you find that are really useful sort of in mediation? I don't know, in a particular sector it could be, or just simply within your country, relating it back, I suppose, to what we've just been discussing.
Yes, thank you. And it was really interesting to hear the insights by the other speakers as well. To be honest, in some matters, it's really similar, the situation in Armenia and in India. Maybe it was similar now. We have some improvements. But first of all, I would like to say huge thanks to Kamala, because what she talked about, the women empowerment and stuff like that, that was really impressive for me. And as a pioneer myself for women, for equal rights and women empowerment, that was really impressive to hear. And coming back to the main disputes, in Armenia, I would talk about two industries, real estate and family right now. Regarding the real estate, I would say that we have done the digitalization of those documents back in 2018, I believe. And I can confirm that we have a big decrease in the real estate disputes in Armenia, because now it's almost impossible to forge documents, and that, of course, plays a big role. Regarding I would like to talk about the family disputes. Why? Because starting from July 1st, 2025, so just 3 months already, family mediation is mandatory in Armenia. So if the family, several types of family disputes, not all kinds. So we have 7 specific types that the law says that if you have a dispute, you have to try mediation first. If it's unsuccessful, then you can only go to court. To sum up this 3 months experience of Armenia, I would say that we have a very good rates regarding the successful mediation in family cases. Of course, some people are still hesitant. They maybe do not trust the process because this is something new. For the businesses, mediation is not that much of a new mechanism because, you know, the business owners, they know more about how to protect their money, how to easily resolve the disputes without losing too much. But for regular people, they do not know much about the mediation process, and they just believe that nothing's gonna happen. We're just gonna go to court and let the judge decide. But when as we mediators explain them what are the advantages of the mediation, that they have an exclusive opportunity to decide for themselves. Because when they go to court, we know a third party, an impartial party, the judge, makes a decision that is binding for both of the parties. But this is like an exclusive opportunity for them to come close together to decide themselves what's going to be their future, what's going to be their fate of their children, their property. So we are just in the stage that we are trying to promote mediation, but I have a very positive impression of those several months, and I believe that we can make mediation more effective in Armenia. We are trying to also make mediation mandatory for employment disputes as well, because we believe that in employment disputes, we can also use mediation to unburden, to take the burden of the courts and also take the burden. I usually rephrase when the government says that we are trying to take the burden off the shoulders of the justice system by bringing those cases to mediators. I say no, that's not the point. The point is taking the burden off the parties, because it's the parties, when they go to court, the burden is on them. They are fighting in the court, they are losing money, they're losing their financial resources, they're losing their their emotional resources. So by making mediation mandatory in some specific fields, I believe that we are taking the burden of those people who have disputes between them, because we give them the opportunity to come together and to not fight and to solve the dispute in a peaceful manner. I would say this was the situation in Armenia.
Okay, very interesting. Thank you. Gosh, I had a question actually when you were talking, and I got so engrossed in listening to what you were saying, it's gone out of my head now. But that was it. So you said though that it was mandatory mediation there. So what? Because actually we have mandatory mediation in Hong Kong, but I wonder what it looks like there. And I'm sorry, we are going a little bit off piece. This is just a curiosity question on my part. What happens if they don't go to mediation?
I'm sorry, can you repeat the last question? What happens?
Yeah, so what happens if they don't go to mediation?
Okay, the law says that if one of the parties in due manner notified about the mediation session and refuses to come, we just stop the mediation. We like sign a minutes of the mediation stating that the one party has, for example, presented herself or himself, and the other party has refused to do so. So the other party can already go to court, because we cannot set too much limitations on the right to access to court. So in that cases, we cannot do much, but let the party go to court. But we try our best to explain both of the parties that let's just give it a try. Let's meet at least once. If you want, we can hold separate meetings, because, in family mediation, it's not usually about just money or property. It's more about deeper emotions, history, relationships. So sometimes they refuse to look at each other, to sit next to each other. So we are trying to give them all the opportunities. If they want to hold separate meetings for the first meeting, we do so. So we are trying all possible ways to make it possible to make the first meeting possible, because once they meet, it's already in the hands of the mediator to guide them through the process. So I'd say that's the hardest part, to make them present themselves to the first meeting.
Interesting. Okay. But so there's no penalty though if they don't do it.
There is no, because it is mandatory, but it's also voluntary, so we cannot
Right.
make penalties.
It's yes, that's it. It's such a party-led process. It's hard to make it otherwise. So okay, very, very interesting. Thank you. So this I think will be a question actually to probably all of you, but I will start with Nara because I'm talking to him, and then I will go around again. Have you found that do you have any sort of specific mediation that you could think of where you've had to significantly adapt your approach to, and it could be due to the complexity of the case or a specific industry, as you were talking about before, you know, to help the parties to find a resolution? Is there any example that you could share?
Well, to be honest, I cannot recall of a very specific example, but again, since we were on the topic of family mediation, I can say that when I first started mediation, I had the chance to join the mediators who are also the mediating family disputes. But that was, you know, as I said, family mediation is really different from regular financial or business mediations. So during that time, I had to adapt my approaches, but thankfully we had some trainings in Armenia for family dispute mediations, because without doing so, I believe that could be a little hard for me to understand what's the best approach in family mediation in order not to harm the parties, because both of them are usually in they are very fragile. It's really easy for them to get to, if you're even being respectful, they can catch that as a disrespect towards them. So it's really, really hard. But thankfully, we had some trainings, and thanks to that trainings, we kind of readapted our approaches to mediation. So usually I divide mediation into two parts. If this is family mediation, I'm totally different mediator. And if it's like business mediation or anything that's not about like family cases, I'm totally different mediator. And I think that kind of helps the whole process, because the parties also, when they see that the mediator is understanding them in a deeper emotional level, they tend to speak up. And as we know, that talking is the most crucial part in mediation. If they do not talk, we cannot succeed.
Very true. Thank you. Very interesting. Okay, so Surinder, I think maybe you could tell us, have you found that you've had to change your approach in any specific mediations? Or do you find that for every mediation, it's always the same, you're following the process, or have you had to really, in the same way, have you had to adapt?
I'll cite an example of where it was an international mediation. It was with a family mediation in Mauritius. It was a family business mediation in Mauritius, where the main language is French. And most of the documents and everything, discussions were to take place in French. And I had not even an iota of about what French language is. So immediately, the other two judges were very stubborn. They knew French very good. They were very well conversant with it. But I had a lot of problems in that. So what I did was I started learning French through YouTube classes. And then there is an institution also where our Institute of Chartered Accountants also does it, from Alliance Française in Hyderabad, where Kamala belongs to. And third is that in New Delhi also I had attended physical classes for 2 months. So all these crash courses I did in order to understand and enter into that mediation. That was
Wow.
a challenging thing for me.
Wow.
Little
That's
bit of French I learned.
very interesting. Wow. Okay. Gosh, I don't think that I could ever learn a language that fast to be able to understand anything going on. I'm very impressed.
But to be very frank with you, I took the help of Google Translation and those things most of the time. And
Okay.
to be very frank with you, I am being a chartered accountant. I read a lot of literature from OECD about international taxation and United Nations also. They come up with all the documents in 5 languages, that whatever are in the Constitution of United Nations. So I could get the English version and the French version. I used to read both in front and stand in front of the mirror and try to learn and speak those both the things, English as well as French, and learn from the mirror itself and YouTube.
Wow. Wow. Very interesting.
Commercial terms are not available on either in Alliance Francaise or on YouTube. So commercial terms, taxation terms, all those things I learned from the OECD
Okay.
website and their documents, which were in 5 different languages.
Yeah. Wow. God. Okay. And how long ago was that? Can you still speak French then? I'm fascinated.
Little bit I can understand what the people are discussing.
Okay.
Only thing is that I am not in touch with it now. I went to Canada. A lot of friends were there who used to speak French there in
Okay.
Alberta and other places. But only thing is that in India, very few people speak French about. Only thing, I was involved in one infrastructure project in a hilly area, and one of the officers who used to come from the World Bank, he knew French very well. So we used to discuss about those things.
Okay.
Bonjour, monsieur, all those things.
Lovely. Wow. Okay. That's a major adaptation. So Kamala, how about you? Have you had to sort of go so extreme, or have you had other?
No, I tell you very frankly, as a mediator, if you know the language of the other parties, then it really helps you a lot. You are almost at the same level. Like in India, we have each province has got its own language. If the disputing parties are, say, from Kamala's province or southern states, and if I know a little bit of it and wish them good morning or anything like that in their local parlance, it carries a lot of weight in that.
Absolutely, yes.
On
Yeah.
that note, I speak 8 Indian languages. So I really have seen that that's power from an Indian
It's a
perspective.
power. It's really
Because
very
you're
good
able
power.
to communicate very effectively and you're able to understand, the nuances of what people are trying to say. And I feel like sometimes translation into English is a loss in terms of what they're trying to, say, because there are some words in Indian languages that just don't have a translation in English. Having said that, I learned mediation from, the guru of mediation and the real, godfather of mediation in India, Mr. Sriram Panchu. And so I had a very,
I
very,
also learned from
great.
him. I also learned from him.
I had the opportunity to watch him and, school my style of mediation. And I think the one thing that he taught me is that it always is different. I think every situation, every dispute is different. And so what we have to do is have the EQ to be able to understand what is it that we need to do for the party, for the dispute, and then create an approach that is very, very specific. So I have, over the last 20 years, done so many mediations, but every single one of them is different. Every single one of them has a different nuance that you've got to look at. The dynamic is different of the parties, between the parties, within the parties, they have certain segmentations and divisions. Understand who the kingmaker is. And then, of course, bring in, elements of emotional intelligence to understand how we're able to break impasses. So I think, there has never been a situation where it's a cookie cutter, one size fits all. But Mr. Kalra, I'm not from Hyderabad. I'm from Bangalore. from Karnataka.
Oh, sorry.
Yeah.
Okay, wow. Wow, very interesting. So I think that I think we've learned an awful lot from you all today, actually. Thank you very, very much. I know that I've got many more questions, but we would be here until midnight, I think, if I asked them all. So I'm going to stop and let.
One point I want to. One minute.
Sure.
1 minute. There is something I wanted to tell about. We are talking about our own country, Kamla, me, Narek, and how mediation is working and doing in our countries. I have some experience in Sharia mediation also, particularly in the financial sector, in the sense that when we talk about interest, Narek was also talking about interest being paid in the financial sector. I was also only talking about EMI and interest to be paid. In Sharia financing, the interest is not there. They don't have interest. When they borrow or they pay and give any loan, there is no interest element in Sharia financing. Interest is considered, in Arabic, it is called haram. Haram is not permitted. It is bad.
Okay.
And they have certain financial products called Madraba, Mushraka, and even bonds, they don't carry interest. Sukuk, they're called Sukuk. Sukuk doesn't have interest element in that. So they have a different type of disputes in the financial sector. Particularly, I learned this from Malaysia only, where you are at the moment. There's an institution called Red Money. I did an Islamic finance course from Red Money in Malaysia.
Okay.
And there are two schools of thought. One is a Malaysian school of thought, and another is the Arabic Saudi school of thought. Saudi school of thought is more rigorous. And there is one institution called AOAFP in Manama in Bahrain. They issue the standards for this.
Okay.
Which are applicable globally. And you see, you'll not believe, there is a separate window at the London Stock Exchange for the Islamic products. There is a separate window at Luxembourg Stock Exchange for the Islamic products. And even banks like HSBC, HSBC is not an Islamic bank. There are certain specialized banks in Sri Lanka, Bangladesh, more than half a dozen banks are Islamic banks. In Saudi and even in Bahrain, I have seen, even Saudi Arabia also have seen, I have seen in Dubai also, many Islamic banks are there. But even the English banks like HSBC, they have a window for Islamic financing also. And they're the disputes are of a different type.
Okay. Wow. So it does sound actually then that really some sectors, I think it does sound like you really do need knowledge in then actually, that if you went in to mediate without that knowledge, then the parties actually would possibly not take you so seriously because you don't understand these nuances.
Yes,
Absolutely.
So
I tell you, I was one of the speakers at COP28 in Dubai in 2023. And the topic which was allotted to me was climate finance, being a chartered accountant. And I threw the idea of Islamic finance as far as climate finance is concerned. Because even though there were certain speakers from the Islamic countries, they said the interest is very high and the mortgage is not available for climate finance purposes and all those things. Then I threw this idea that your own religion gives us this idea of Islamic finance. There is no interest element in that. And you will not believe this has been adapted by United Nations now. And even Central Bank of Russia, they have adopted it. Central Bank, even in China, they're adopting now Islamic finance products.
wow, interesting. Okay. Gosh, all right. So you need to keep
Central Bank of Russia, they requested me to submit a paper to them how they would work on Islamic finance, how they can implement it.
Okay. Wow. All right. Gosh. Wow. Okay. So it sounds like we need an extra webinar just on Islamic finance, actually, then. Anyway, all right. So I think there's a lot of webinars that have come out from this discussion. Thank you very, very much. I'd like to let our audience ask questions now. I wonder if anyone
Yeah. Let them
got
ask.
any questions. Yeah. I thought I had seen a question hand up earlier, but it's vanished. Right. Anyone? Jonathan, have you got a question? Oh, here's your question.
No, I just I want to thank everyone. Very insightful discussion.
Yeah,
Very insightful. I think that from a Canadian perspective, I think the mediation just often lawyers are involved in mediations, and what I found is that you've got to have to really read the room when you're mediating, because I think lawyers have big egos, and what you want to make sure is that you're not bruising those egos, and also often hold discussions not directly with the disputants, but certainly with counsel, and first thing I do is kind of meet with them and kind of assess and see where they're going, because some of them will tell you, or people that know me well, and say, listen, I'm only here because I needed a certificate. Then I'm going to go, okay, are you not going to try? And they frankly said no. I said, okay, so why are we here? Like, why, and in many cases I just say, well, that's not me. Oh wait, right, but I know them well, so that to me is very important, because often the clients don't really understand the mediation process, and they don't even I think they may follow their counsel blindly, except perhaps in very complicated commercial mediation, commercial matters where you're dealing with a C and they just say, no, go away, right? Or they may be influenced by their in-house counsel. But in fact, sometimes you just want to get up and kind of, grab the lawyers and say, listen, get with it. Let's not complicate this. You've got you've taken what you want to get, right? Just resolve the issue to the best of your ability for the benefit of the client. It may not be your view, or your counsel's view, but you've got to understand where they're coming from. So the only point I would add is that I always kind of try to read the room, read counsel. And once I get where they're going, where they want to go, and I would try then to tailor my approach, be it evaluative or just kind of conciliatory and just kind of listening and kind of point them in the right direction. Very different than I would do as an arbitrator.
Yeah.
But thank you. They're very insightful for all the panel members. That just kind of the cultural background of the parties are so critical. And
Yes.
I think in Canada we're not quite there, because everyone knows that you need to get a certificate before you go to trial. So that really isn't the incentive, right? The incentive is like, let's get a resolution, because we all know hey, there's certain rules and procedures, and as a litigator, you focus on what you need to do and what evidence you get to get what you want for your client. And if you're monetarily rewarded by that, well, then you forget about the client. You say, what's the evidence to get what I want? Which is kind of like opposite of what reconciliation is all about, or a resolution is all about. Yeah, thank you all.
Thank you very much. I'd like to add some comments regarding what Jonathan said. From my own experience as a mediator and an attorney and a lawyer, because I cannot help but agree with what Jonathan said, that yes, lawyers sometimes when they are in mediation, their mindset is tailored to the traditional litigation, because when they are in mediation, they are still thinking about winning. They just want to win. They prove they are the party that is correct. They are the winner. But of course, we know mediation is not about, it's about winning, but it's about win-win situation. When both parties win, and it's not about fighting to see who's right, who's wrong. And sometimes lawyers bring some evidence with them to mediation sessions and saying, you know, I have this evidence that proves that he or she is lying. That's not correct. And they forget that that's not what we do in mediation, because in mediation we try to see what the party wants and what the other party wants, and it's not about who is wrong, who is right. So yeah, I can confirm, I can agree that sometimes lawyers are kind of how to say, no, I don't know how to say, but sometimes lawyers can tank the process, let's say, and
Being
it's so, of
difficult.
course, yes,
Difficult.
they can. Yes, they can just make it much difficult than it would be without lawyers. But I'm a lawyer myself, and sometimes I'm also representing my clients in mediation processes. And being a lawyer myself, I know it's really hard for the lawyer's perspective as well, because sometimes some clients think that I've paid the lawyer. Why is he seated here silently? Why is the lawyer not doing his job or her job? So I understand that it's really challenging for the lawyers as well. But we have to just find the right balance in order not to tank the mediation and not to disrespect the relationship between the lawyer and the client.
If I may come in here, Alex, Narek, I think you made an absolutely vital point. I think just like how we have an arbitration bar, where we have arbitration practitioners who are lawyers, who are trained in arbitration, we need to have a mediation bar where we have trained lawyers who are mediation counsel. Because I feel like the role of a mediation counsel is very different from the role of a litigation or an arbitration counsel. And just like Narek and Jonathan just now said, right, in litigation or in arbitration, you're trained to go after the person, right? Whereas in mediation, you've got to hold that restraint, right, and step back and know when not to speak and when to let your client speak. And I feel like, in every mediation I've done, either as counsel or as mediator, the more the mediation counsel is trained and understands the process, the higher the chances are of that mediation being a success. So really, we should look at putting together a mediation bar where we support each other in this journey of making sure that we have good practitioners who are able to, navigate the process along with the mediator to make sure that it's a win-win for all. Because otherwise, litigating counsel, like Jonathan said, just want that stamp to say, yes, I've tried mediation, it's failed, now I'm going to arbitration or litigation. Just get out of my way. I'm going to fight and I'm going to make a lot of money in the process. I don't care what my client thinks, And I feel like that's a process that is really a disservice to mediation.
I'd like that. Yeah, go ahead, Jonathan.
On that, it's also I pinched myself because when I started, my first degree is in psychology. So I had to say to myself, step back, take deep breath, listen. And when I want to raise up, say something, I just say, nope, shut up, sit down, and listen. Sometimes it's very hard. I agree. It's very hard to switch. As a litigator, you want to get up and you want to do it with it. No, deep breath, and then listen.
Yes. Yeah. And it comes naturally to some people and it doesn't come naturally to some people. But I think one should be self-reflective and say, listen, if this is not my cup of tea and if I'm not mediation counsel, I shouldn't be doing it. But I shouldn't derail the process and disrespect the whole dispute and the intentions of the parties by coming in to derail the process.
Yeah. And I would like to just add that in order to avoid the impression that lawyers are always the ones that are faulty, or let's say not to pin the whole thing on the lawyers, I would also like to say that in Armenia, we have the Chamber of Advocates of Armenia has trainings like once or twice a month for lawyers regarding mediation. Usually mediators are doing those trainings. And I've seen that those are really helpful because I can speak from my two recent cases that the lawyers have been extremely helpful in family mediation even, because in family mediation, we try to minimize the involvement of lawyers because it's more about personal matter. But they have been really, really helpful, really cooperative, and I believe their role has helped the whole process because we signed the mediation settlement agreement within those cases. So not to forget those lawyers as well, that there are some lawyers who are really helpful and we should appreciate them and promote the way they work. So yeah.
Yes, yeah. You're absolutely right. Yes. Well, thank you so much, everyone. That was a really, really fascinating discussion. As I say, we could be here for much, much longer, but I think we should probably end it here. So I really appreciate everyone's time. Thank you for coming and listening as well. Thank you also to Resolve Academy for hosting this. Thank you, Marlene, most importantly. Has done a lot of these logistics. So I look forward to speaking to you all again, and thank you. And we will end here, I think. All right.
Thank you.
very much.
Thank you. Bye-bye.
Have a good day.
Thank you. Thank you.
Thank you.
Oops.